Good morning, everybody. We're getting started in about 8 minutes.
Good morning.
Good morning.
Good morning. Hope everybody can see my screen.
I can see it.
Okay, good morning, everybody. I put the red line of the presentation of the contracts in the chat. So you can grab that PDF and download it if you'd like. Take a look at it. See all the red line and the committee's notes. Looking forward to seeing everybody. We're going to start in about 5 minutes. All right, we got about 2 minutes to go till we get started. I don't know if you can see in the chat, I posted the revisions. Hopefully you scroll all the way up to the top, you can see that. Let me know if you can't. What we're going to do is we're going to email a video link of this to everybody afterwards once it's posted to my YouTube channel. And I believe we're going to have the option to include the PDF of the red line in that email as well. So, and I put the red lines in the slide, so you'll all be able to follow along. Let's try reposting and see what happens. All right, I just reposted it. Hopefully you can see it now. Let's try this again. All right. We'll email the red line out afterwards. That's not going to be an issue. Okay. All righty, I have 10 o'clock, so we're going to get started. I don't want to waste anybody's time. I want to get right into it. My name is Sam Saad, and we are going to be talking about the 2021 FAR contract changes. Very excited today. We have almost 500 people on the call. So what we're going to do in terms of questions, I'm going to go through the changes. If you have a question, please post it to the chat, which I am monitoring. We are not using the Q&A on this call. And then we're going to take questions at the end. You'll be able to shout them out at the end. So with this many folks, it'd get too crazy if we did war stories and questions during the presentation. So if you have questions, please post them to the chat, and I'll call you out. Okay, so I'm an attorney. So the first thing we're gonna do is have a disclaimer. I'm not providing legal advice. If you have specific legal questions, you need to contact me and set up an attorney-client relationship. A little bit about my offices. We were founded in 2007. We focus on real estate and business law, and we are dedicated to helping small business owners, entrepreneurs, buyers, sellers, property managers with all of their real estate and business needs. And don't forget, as a realtor, you're a small business owner. I believe most of you are independent contractors. So if you have any questions about your business, you can always give me a call. We have a full litigation department, and we have offices throughout Southwest Florida, but we close transactions across the state. A little bit about me. I am now working on my 18th year as an attorney. I focus my practice on real estate and business transactions, and I'm a member of the NABOR Legal Resources Committee and the reptile section's Real Estate Industry Liaison Committee. So I'm on the committee that oversees the reviewing of the FAR contract that we're going to be talking about today. And let me just dive right in. We are going to talk about the red line of the FAR. So we're not going to go through every single line of the FAR contract. We're going to talk about the FAR as is, and the riders. And I'm going to point out the changes that the committee has adopted for 2021. These changes are active and in Form Simplicity, Zip Forms, your other forms providers. They should be ready to go, and you're going to be using these forms if you write on the FAR form set. I'll also put a plug in for don't mix the forms. Those of you that prefer NABOR or the Northeast or other FAR forms, the riders that I'm going to talk about at the end of this presentation apply to the FAR forms. And let's just start right away. We're going to walk through. You'll see that I've got the line numbers on the left side. I'll tell you that those line numbers are not going to line up perfectly if you're looking at a non-red line form, because when the red line comes out, obviously the line numbers change. So starting right off at the beginning, the committee went ahead and adjusted the smart home feature features of the contract. And basically what they added here was thermostats, doorbells, television wall mounts, and television mounting hardware are now included, along with mailbox keys, storm protection items, and other hardware. And they want to make sure that the panels, the screws, the bolts, and whatever else you use for storm protection need to stay, along with the smart home features. One thing to point out is televisions do not convey. So again, this does not change the old adage, if it's screwed or glued, it stays. It just clarifies that those things that you add to your home for smart home, they'll stay. Next section of the contract, paragraph 2, they modified the escrow agent information to give you more space. That was always a cramped space. And a good question from Amy Alvarez on the last slide. Yes, washer and dryer still do not convey, and neither does microwave. So if you want to include those items, you need to write them into the blank. Washers and dryers do not convey. And that's a continuing source of frustration for some realtors who either list washer and dryer convey in the MLS and have to buy them for the buyers, or buyers agents will tell buyers that the washer and dryer conveys when it doesn't, and then they have to provide them. And so just note that, be very careful there. The other thing that they changed in this contract, going back to paragraph 2 here, note at the very bottom of this slide, they crossed out and unbolded collected. You have to use collected funds, which means funds that are ready to be distributed. You can't write a check at closing. You have to use a wire, basically. And there's a standard in the contract that covers this, but the committee felt that it's not a new concept anymore, so they just removed the bolding. Okay, so next section here, paragraph 4, the definition of closing was redefined, and they clarified that the closing date can be modified by other provisions of the contract. I want you to note on this slide that the closing of this transaction shall occur, and then it lists conditions. When all funds required for closing are received by the closing agent and collected pursuant to standard S, and all closing documents required to be furnished by each party are delivered. So that's when the closing happens. There's been some questions about, closing in escrow, dry closings. The closing happens when all the money is there, and it occurs at the date provided unless modified by the other times established by the closing agent. And the question comes up, what if the funds are not collected? Well, the contract says they have to be collected. So if you don't have collected funds, i.e. if you don't use a wire for your closing proceeds, then you will, your buyer will be in breach of contract and they will lose their deposits. Next up in paragraph 5, they changed to an extension of the closing date. Used to be that the Consumer Financial Protection Bureau requirements gave you 10 days. That's been shortened to 7. And you have 3 requirements that have to be met for you even to get those 7 days. 1, there must be financing, and we're talking great detail in a few minutes here about the changes to the financing provisions. The loan approval, which is a defined term, again, that we're going to talk about, must be obtained, and you must have a clear to close from the underwriter. And that means that they say here the lender's underwriting is complete. So if the property or the borrower is still in underwriting and the closing date arrives, you don't get 7 extra days to complete underwriting. And that's a source of confusion and frustration for a lot of folks. Yasmin is asking, what if the lender doesn't get the funds out in time? Well, assuming, Yasmin, that if the lender is prepared to send the funds, assumes that the underwriting is complete, that you have loan approval, and that there's financing. So that would be something where if the lender sent the wire at 4 o'clock and we didn't get it till the next morning or something like that, that would be an event where we could use the 7 days. Amy is asking, can you elaborate on what the CFPB extension is? When does this come into play? Amy, this comes into play when the buyer has gotten financing, when their loan has been approved, and when they have their clear to close, but they don't have documents ready. So for example, if it's a closing day, loan has been clear to close, but the lender is backed up, they can't get the docs out, or they couldn't get the CD out within the 3 days. You need a few extra days, not more than 7, to get the loan closed. Then you would have 7 days. Again, if you're still in underwriting, you don't get 7 days. And then Tom is asking, are those 7 days business or calendar? They're calendar days, and there's a provision in the contract for an extension if the 7th day falls on a weekend or legal holiday. Okay, make sure there's no other questions in the chat. Okay, occupancy and possession. This is just a little bit of a cleanup in language 6A. Unless paragraph 6B is checked, the seller shall at closing deliver occupancy and possession of the property free of tenants, occupants, and future tenancies. They added that if you're going to do a pre-closing occupancy and you use the rider, then this changes from the closing date to the date the buyer takes possession. And then in paragraph B, we just clarified that seasonal leases and vacation rentals are included in the disclosure that's required by the seller, but that you do not have to provide tenant estoppel letters for seasonal and vacation rentals. Why is this important? It's very difficult to get a hold of your seasonal and vacation rental customers, especially if they've only been communicated with through a VRBO or an Airbnb type website, and get them to sign an estoppel. So we take the affidavit from the seller saying that the rent is X, that so much has been paid, and we go from there. If those things are not acceptable, then the previous default of 5 days to deliver the information and 5 days for the buyer to review it does not change. Okay. Paragraph 7, this is a big change. Used to be that the default, the common law default for any contract in the state of Florida was that the contract is freely assignable. And the FAR bar included these check boxes that you can see on your screen for may assign, may not assign, or may assign, but the buyer may not be released from liability. The new default, if you miss this section of the contract, which many realtors don't check a box, is that the contract is not assignable. This is an important change.
I'm trying to
Because
hear
if
this
you don't check assignable and the buyer wants to say put it in their trust or put it in an LLC, you can't have that happen without seller permission. Okay. Now, let me just say, if you want to ask any questions on the first part of the contract before I get into financing, go ahead, unmute yourself and ask your question. I think I heard
This
it.
is Ken.
Yes. Go ahead, Ken.
Actually, I'm tuned into a webinar right now. Jody,
Okay, Ken's mistaken. All right.
I have a quick question.
Yes, honey.
On the extension of closing date, do we actually have to get an extension addendum or does it default?
No, it's included in your contract. It's a great question.
Okay.
You do not need an extension document signed. You have 7 days per contract. Okay. All right, let's get into the financing. So the financing provisions, this round of contract provisions was a major rewrite. We had a bad court case. Some of you may have heard of the Lafont decision. I've talked about in some of my webinars. This court case basically knocked out a buyer's deposit when the buyer didn't have loan approval, and that was because they didn't apply for the loan stated in the contract. So this was a big to-do amongst attorneys. We had to go in and do a major rewrite of the contract. And so we're going to start off, I want to give you some definitions so that you know what I'm talking about when I go through the next several slides. First definition we're talking about is the loan approval period. This is the time that the buyer has to obtain the loan approval, and it's a 30-day default. Next up, the next term that we're going to hear about is financing. There's the contract says that when the buyer is getting financing, certain things happen. Financing are the terms upon which the buyer seeks to borrow money, including the interest rate, the type of loan, and the term of the loan. Next up, the next defined term you're going to see is appraisal. The appraisal or alternative valuation satisfactory to the lender. An appraisal is, of course, what you think it is. It's if somebody comes out and says what the value of the property is based on the comps or the rebuild price. The next term up is loan approval. A loan approval is a loan that meets the financing and the appraisal terms. And if there's a reference in here to rider B, which we are going to talk about. So let's dig right in. This is the first section of the financing contingency. Note, this is for cash closings. And if you see here, it very clearly clarifies, simplifies the section, deletes all the extraneous language. This is a cash transaction with no financing contingency. That's all that's left of the old contract regime that talked about acknowledging terms and conditions and CFPB requirements are not affected. None of that it was all superfluous language the committee decided. And so now if you're doing a cash transaction, that's it, cash. Now, don't let this confuse you. If you've signed a cash contract, but your buyer intends on getting financing, standard L of the contract, which has not changed, creates access for inspections, appraisals, and other requirements that the buyer may need for access to the property. So just because you're getting cash or signing a cash contract but getting financing does not mean that you don't get access to the property for the inspection and the appraisal. And that's an important question that I get a lot, where people will come in and they'll say, this is cash, I'm not letting the buyer in for the appraisal. Well, in the FAR contract, it's very clear that you have to do that according to standard L. So that's not really a question. Okay, so when you are getting a loan, used to be that the contract was contingent upon the buyer obtaining approval of a conventional FHA or other loan at a fixed adjustable rate for a certain amount of time. Well, because of the Lafont decision, we had to make some changes. Notice here, this contract is contingent upon in so many days, 30 is the default, that you get your loan approval period. And that's where you apply for your financing. And you also note here, make this yellow and as big as possible. And you have to get the appraisal now within the loan approval period. Appraisals are running at least 2 to 3 weeks, sometimes longer, and some lenders won't order the appraisal until it gets to a certain point in the underwriting process. You need to educate your loan officer, and they need to educate their underwriting department. You cannot wait to get the appraisal anymore. You got to get it, and as we're talking about on the next slide, the buyer has an obligation to pay for the appraisal. So it's no longer a question of, well, I'm gonna do all my other stuff, I'm gonna do my inspections. No, get the appraisal, get it done, and make sure the property appraises, or that there's some alternative valuation of the property satisfactory to the lender prior to the loan approval period ending. I can't stress this enough. This is a big deal. Getting these appraisals done is going to be an interesting situation that we're all going to have to go through. Next up, made some additional changes to the paragraphs, to the financing paragraphs. You'll make application for financing, and we said that's the defined term. That's the kind of loan that you're getting, and you're going to do it within the loan approval period. We have a question here from Pearl. If the appraisal value is not acceptable by the lender, Pearl, we're going to talk about that here on the next slide, but basically the buyer terminates. And if they can't bring cash to the table and it doesn't appraise, they're not going to get their loan, then the buyer has the right to terminate. So the buyer now has to use not just a diligent effort to obtain loan approval, but a good faith and diligent effort to obtain loan approval. And that includes paying for the appraisal and other fees and charges imposed by the lender. So don't forget, now I'm going to say it again, get your appraisal done early. Tell your buyer they're going to pay for an appraisal, whether they want to or not. And it's going to be before the inspections are done in most cases. And of course, the default is 5 days to make loan application. If the buyer is selling their existing property, it's not a condition for loan approval unless rider V is attached. That's another important change. Make sure that you're using rider V for for selling your existing property. And I've got rider V later in the slides. We'll talk about it in greater detail. Okay. So the buyer also has to keep everybody informed about the loan process, the appraisal, the loan approval, including any property related conditions. In this contract, the buyer authorizes everybody to talk to everybody. That's your lender, your mortgage broker, your closing agent. Everybody gets to be informed about the loan. And then here, if within the loan approval period, buyer obtains loan approval, buyer shall notify seller of the same in writing prior to expiration of the loan approval period. So this is a new duty on the buyer. They now have to give written notice of the loan approval in the loan approval period. Or if they're unable to obtain loan approval, but they're satisfied with their ability to obtain it in the future, then we proceed to closing. If you don't give your notice, then the seller gets a 3-day right to terminate. I have a question. Can the buyer change type of loan without risking deposit? That's an excellent question, Kristen. So I would say that based on the Lafont case, you cannot change your loan type without an amendment. If the buyer's going for a conventional loan, but they don't qualify because they don't have enough cash, for example, but they do qualify for a FHA loan because they have the smaller down payment and good credit, and they want to switch from conventional to FHA, I would absolutely, because of the Lafont case, do an amendment to contract that says buyer hereby changes their loan type from conventional to FHA. That's an excellent question. Karen is asking, if the bank is ordering the appraisal, how can the buyer's agent control how fast they order it? Karen, another excellent question. You need to talk to your lender, your loan officer, your mortgage broker that you deal with before you go to contract and explain to them, hey, Bar changed the form. You have to get the loan, the appraisal earlier. Can you do that? And the lender is very likely going to say yes, because they want the business, and you have to stay on top of it. David, what if the buyer stays conventional but goes from 25% down to 10%? So the loan approval has to be in at least the amount stated on page 1 of your contract. So if you have a 25% down on the contract, but you want to switch to 10% down, again, you will want to get an amendment to contract so that you are applying for the loan that you said you were applying for in the contract. I think that's very important in the case under the Lafont decision, that the contract needs to match the loan that's being applied for. If there's a change, you need to amend the contract. And again, if it's not something the seller is willing to agree to, then the buyer would have a right to terminate. Let's see here. Pam is asking, if buyer does not notify seller in writing that they have a loan approval, seller has 3 days, where can they terminate in the contract? I I think that is on the next slide. So here is the next slide. You can see here, if the seller, where is it? Oops. Sorry, it's on this slide. Within 3 days after expiration of the loan approval period, Pam, that's where it is. It's right there. So if the buyer does not get loan approval, does not waive the financing in writing, then the seller will get 3 days at the end of the loan approval period to terminate, and the buyer will get their deposit back. Marsha, I'm not sure I understand your question, but basically, if they don't, the seller gets the 3 days at the end of the loan approval period.
So this is Marcia. Thank you for clarifying. Until I saw this, my misunderstanding was that the buyer was getting 3 additional days. The seller, if this date goes by, has 3 days within which to cancel if they choose to do so, right?
That's correct. Yes.
Thank you. Thanks for clarifying.
Yep. Okay, Amy says, what was it before the change? It was always 3 days. It was just the seller, I'm sorry, the buyer didn't have to give written notice of loan approval. That's the real change. And Carrie is asking, in NABOR contract, do they have to amend the contract as well if we go from 20 to 10? Carrie, I'm very conservative. I think some other attorneys may give a different answer, but I would say yes. I don't like the LaFont case. I think it's a bad case. I think it's a bad decision. It makes some sense, but it doesn't really produce a good result. And I would say that yes, in the NABOR forms, you would still want an amendment if you change the financing provision, the financing terms, excuse me. Okay. So the buyer will lose their deposit if they don't terminate and they don't close. We removed the whole section here on the appraisal contingency. There are still property related conditions that have to be met in the loan approval. Those may be a source of ability for the buyer to terminate and get their deposit back if the property related conditions cannot be met. Pam is asking, so buyer must notify in writing of the loan approval, and if they do not, seller can cancel within 3 days. Pam, that's correct. Okay. Any other questions about the financing? I know it's a lot of change. It's a major rewrite. Before I go on, any questions about paragraph 8 financing? Solace, what happens if seller does not terminate within 3 days? Can it terminate later? No. If the seller doesn't terminate at the end of the loan approval period and the buyer has not waived or terminated, then the contract becomes basically a cash contract and you go to closing. Other questions? Christina, yes, you are correct. So if the buyer has to tell the seller it's approved versus just waiting for the period to end. And this is kind of a big deal. Cindy is asking, can the buyer terminate if he's not happy with the appraisal? Well, you have to exercise good faith and diligent effort. If the appraisal comes in at the right price, at the sales price, I think it'd be a hard argument to make, Cindy. But if it comes in low, then yeah, you can terminate. Barbara is asking, not obtaining insurance, property condition on that. No, you have to get your insurance put in place. There's no provision in this contract for insurance failing to get insurance like the NABOR contract. Barbara, I don't understand your question there. Rob is asking, if the buyer states cash and then gets loan instead, is that all right? Rob, yes, the buyer can make a cash offer and then get a loan. They just won't have any protections in the contract if their loan falls through, and they don't get 7 extra days if the loan does go through, but it's going to be late. You have to hit the closing date. Gwen, the buyer's agent, can inform the listing agent. Okay, okay. All right, let's keep going here. Barbara, yes, you can check cash and get a loan. And then Alyssa is asking if the buyer says nothing after a 30-day approval period and the seller doesn't terminate in those 3 days, then the buyer must move towards closing. It's basically a cash deal at this point. Alyssa, that's exactly correct. And Robert, yes, do an addendum if you want to switch from cash to financing. And Robert, you make a good point. Many sellers won't accept appraisal contingencies. Does this help them or buyers with the change? It helps the buyer because the buyer in a finance deal is going to have to get an appraisal whether the seller likes it or not. And it's an opportunity for the buyer to get out during the loan approval period if the property doesn't appraise. Okay, let's keep going. We got a lot more to cover. So section 9, it was always the case that the seller was responsible for FERPTA, but it wasn't clearly stated. It now clearly states that charges for FERPTA withholding and reporting are seller expenses. That's an easy little change. We clarified in paragraph 9C that the seller provides a copy of their title insurance policy, and that in Miami and Broward counties, the buyer designates the closing agent. That was also always the case, but it was not clear. Now it is clear. Okay, this is a big change, and this is going to be an opportunity for a buyer to extend the closing date if at least 5 days prior to closing, the buyer may, at their own expense, get a survey. So it used to be that you had to do it prior to the much earlier in the process. So if you're 5 days out from closing and the buyer delivers a survey to the seller and says you've got encroachments, then you've got a problem, and you could have up to a 30-day or more extension while the seller deals with the encroachments. That moves the shed, fixes the fence, deals with the air conditioner pad, whatever changed, the pool cage that went over the line. All of those things are now those are all used to be dealt with during the closing process. You may now be on extension for up to 30 days or more because the survey was delivered 5 days prior to closing. This can be a big deal. Strategically, this can be a pain in the butt. So make sure that you are paying attention to survey issues as well. And of course, your closing agent should be ordering the survey. Amy says, where does it state you have 30 days secure? That's in standard A2 and B, Amy. Okay, special assessments. So this clarifies that the seller pays the full amount when allowed by the public body. If the public body does not allow it, then you pay in installments pursuant to 9F sub A instead of 9F sub B. If the clarifies that the charges are split, if there's no box, it's just the new default is option A. And this does not apply to special taxing districts or CDDs. That's always a source of confusion. This is an interesting change. So in paragraph 12B, which is your inspection provisions, watercraft, lifts, and related equipment are now specifically included in the list of items that a buyer may inspect. So if you're selling on the water, it was a question before whether the dockage included the lift. It includes the lift now. Again, this clarifies here, this is the general property repair section, that the seller may have general repairs completed without getting estimates. So if you recall now in the regular FAR/BAR contract that the seller has allowances, the default is 1.5% of the purchase price. If you come back with your inspections and say, you know, fix these screens, fix this fog window and these 15 broken tiles, and it costs less than 1.5% of the purchase price, the seller doesn't have to go get estimates. They can just make repairs using licensed contractors, of course. Okay, so this is a big change here, removing the 5 p.m. deadline after a public holiday. So the time was always of the essence in the contract. They just moved it to the front of the paragraph to make it more clear and remind you that time is of the essence, and that calendar days based on where the property is located shall be used in computing time periods. And that's where the property is located, because we have 2 time zones in this state. Don't forget that, for those of you that are out in the Panhandle on Central Time or work across that line. The 5 p.m. deadline used to be that when the deadline fell on a holiday or legal holiday, it went to the next business day by 5 p.m. It now goes to the next business day by midnight, 11:59. Force majeure, of course, with the pandemic, we had some issues. Now we are clear. We add to the definition of force majeure that pandemics are and epidemics and government shutdowns and mandates are force majeure events. And it clarifies that when the force majeure event starts, when the force majeure event starts when the first day of the effect of the force majeure is felt. Patricia is asking, do small repairs need to be fixed in as-is contracts? As-is contracts are as-is, Patricia. You have to negotiate that. If the buyer wants small items fixed, they got to go to the seller and ask for it. That's a negotiation event in an as-is contract. That's not a rule. Okay, moving right along. So you may not be aware of this. This has been in the contract for a while. The FinCEN, the Financial Crimes Enforcement Network Geographic Targeting Orders. Anybody can say that 3 times fast. That's the Financial Crimes Enforcement Network Geographic Targeting Orders. Those are in place to report if you are in Miami-Dade, Broward, or Palm Beach counties. You cannot have anonymous buyers. Have to go all the way back to the individual, and they have to produce photo identification of the individual who or the beneficial owners of the entity that is attempting to purchase real estate in South Florida. There's no way around that. If you put it in trust, you got to name the beneficiaries. You put it in LLC, you got to name the owners. If you put it in a corporation, you got to name the shareholders. It's a very broad base, and it's basically designed to prevent what we all know goes on in South Florida: money laundering and drug trafficking, and now human trafficking. Dana Land Trust, same thing. It's pretty broad based. The FinCEN order, the GTO order. Christina is saying, well, it could be up to interpretation as to when that's. So Christina, that's actually a great point. Just going back to force majeure real fast. Christina says it could be up to interpretation as to when the force majeure event is felt. I'll tell you, in this whole pandemic, you know, my office stayed open. We closed transactions. We didn't stop closing transactions. Where we had issues with people who were in California or in the northern states that were locked down, we used remote online notaries. We sent notaries to people's homes. We got them all closed with very little difficulty. So I would argue that the pandemic, while it's now included in the definition of force majeure, it also says by exercise of reasonable and diligent effort, the non-performing party is unable in whole or in part to prevent or overcome the force majeure. So it's not a blanket, oh, there's a pandemic, no transactions. That's not the way it works in a force majeure event. Deb is asking about the FinCEN order. It does not apply in the entire county, only to Miami-Dade and Broward in Florida. Okay, so next change. This is also an important one. Text messages do not count for notice. Email, fax, personal delivery, or US mail are how you must give notice. You cannot text the listing agent and say buyer waives their finance contingency and You have to do it in writing, and you have to do it in an email, a fax, personal delivery, or US mail. Thank you, Cindy. Yes, the Brazil one was an interesting one. But it limits, so the delivery is limited, and you cannot record this contract in the public or official records of any county in the state. So you can't record the contract. I'm gonna say it again one more time. Text messages are not noticed in this contract anymore. Don't use text messages. Okay. Now, we talked about this earlier. Collection or collected means checks tendered or received, including deposits, have become actually and finally collected and deposited in the account of the escrow agent or closing agent. So basically what this means is no checks for closing. You have to use a wire. You can't use an ACH either because that can be pulled back. You've got to send a Fed wire for your closing proceeds. You just got to do it. It's unfortunate, but that's the way it is in this world of check fraud and everything else. They cleaned up the addenda section. There's a mold inspection has been added along with seasonal and vacation rentals and PACE. This means that includes cashier's checks. There's the cashier's checks. I've had over $3.5 million of cashier check fraud attempted in my office. Only wired funds is exactly correct. People will, what happened with cashier's checks was, and this was like 10 years ago, like RBC lost a batch of like 100,000 checks. So basically any check from Royal Bank of Canada is probably a fraud, any cashier's check at this point. Okay, let's move on now. Any questions about the contract? Amy says mold inspection is not on the as is. Yes, it's mean that's only for closings. The buyer can still make their initial deposit by check. Amy, you're saying the mold on an as-is contract, you don't need a mold inspection addendum. As is. You go in, you do your inspections, the buyer inspects, they find mold, they go to the seller, hey seller, we found mold. We want a credit, we want remediation. If you don't give us a credit and we don't close, you're gonna have to disclose this new mold problem to your next buyer and get a lower purchase price. So please work with us and let's get to closing. That's how you handle mold. Jason, they did say that the contract has never been able to be recorded, but they just clarified it. It used to say public records, now it says official records too. Other questions about the contract before I move on? Solace, you're asking the major difference between the as is and the FAR bar, when to use each, which one, new construction. Okay, that's a little bit outside the scope of this presentation, but very briefly, an as-is contract is a contract that says buyer wants to look at the property, make a decision, and then renegotiate. This contract, the FAR bar regular contract, says buyer agrees to conduct inspections, give a list of inspection items to the seller, and seller is required to spend up to the amount stated in paragraph 9A, which is defaulted to 1.5% of the purchase price. The seller doesn't have an option in the regular contract to not make repairs. They must spend the money up to 1.5% of the purchase price or whatever is written in to override the default, if that makes sense. Okay, let's talk now about the riders. There were several changes and some new ones. So we're going to go through these. Rider B is the HOA rider. If special or other assessments are levied by the association, exist as of the effective date, any assessments are levied. Or is it here? It says here, if they're due and payable in full prior to the closing date, then the seller shall pay them all prior to closing. So that means this was an issue, I think, before the closing date. Notice that NABOR, by the way, is prior to the effective date. So if the association has a special assessment out there prior to closing, seller pays it. And then the seller has to also pay all their fines and estoppel fees. which there's been some problems, sellers pushing back on that. The changes to the FHA and VA rider, I didn't copy in because they're very small, but it just clarifies that the seller will comply with lender requirements for inspections and appraisals up to the limit stated in the contract. And it very clarifies that the limit for VA inspections and appraisals is in addition to the paragraph 9 seller expenses. And if the seller has to pay the VA fee up to $250. So this is an entirely new mold inspection rider I, and the mold inspection must be by a licensed inspector. There's a 20-day default to complete the test and deliver the reports. The buyer gets a right to terminate if the remedial action exceeds the amount stated here in the blank that I'm highlighting. Essentially, this is an additional out for the buyer if they find mold. The pre-closing and post-closing occupancies make the same change. They clarify that you can have a pre-closing occupancy agreement or other similar agreement. You do not have to have a straight up quote unquote lease. It can just be, you can do a pre-closing or post-closing occupancy agreement. It's a license. It's a license that basically helps get around evictions. And if you're familiar with the NABOR forms, you're familiar with this license as opposed to a lease. Okay, Janet is asking, do we include any new riders in a listing? Janet, I am a big fan of putting seller docs in the listing. So if you've got a HOA or a condo rider, the seller's got to sign that and make disclosures. I would go ahead and put those in the listing and ask that they be included with the any offers. That's how I would handle that. Christina, this does not differentiate between types of mold like the NABOR contract does. This mold addendum just says mold. If you find mold, it also doesn't include an air quality test like the NABOR contract, which the NABOR contract says that if the mold content inside the home in the air sample is greater than the mold content outside the home in an air sample, then you have a mold issue. This contract, you could have visual mold, you could have mold in the walls, mold in the air. As long as it costs $500 or less to remediate, you go to closing. If it costs more than that, the buyer can terminate. Jackie, I think it has answered your question. So this is a new rider, change to rider B. The buyer's property must close by the date stated here. The buyer has to give a copy of the contract for his sale or there's no contingency, so you have to provide that copy. And then the buyer has 24 hours from the effective date of the buyer's contract to deliver it. This is very poorly written, this language down here. Basically, the buyer has 24 hours from the effective date of the buyer's contract to deliver an executed contract if they don't have an executed contract when they sign the contract for the purchase of their new home. Be very careful about this. It's very poorly written and it needs to be cleaned up. Benia is asking, would you add the mold addendum to all contracts? Benia, I would not. It just depends on the property. If you have a musty smell, if it's an older property and you want to have it double checked, then you could do the mold addendum. But remember, it's a seller's market. If there's no reason to do it, I wouldn't add an extra contingency. You're just going to make your seller mad. Sherry is asking, what liability do sellers have concerning the seller's disclosure with regard to mold if seller says no mold and buyer finds mold? Sherry, you would, if I'm the buyer and I find mold and it wasn't properly disclosed, I would go to the seller and say, listen, there's mold in your property. You know, and I'm assuming it's an as-is contract because that's the most popular contract. I'd say, hey, listen, I found mold. I want a reduction in the purchase price, or I want you to remediate this mold. And if you don't, I'm going to terminate, and you're going to have to tell your next buyer that there's now mold in your property. And then they can make a decision on how they want to proceed. Christina says supplying contract from out of state, couldn't that have legal ramifications with, let's say, the buyers from out of state? Christina, I'm not sure I understand your question. You want to unmute yourself and ask? Christina?
Yes, sorry. So I have buyers currently in Michigan right now buying in Tampa. So if I, thank goodness they're already under contract and all that stuff, but if I had to supply their contract from Michigan, right, they're the sellers now buying in Tampa, am I going to have like a release from the buyers up in Michigan? Because it's going to have their information on that contract and I'm just giving it over.
You're not going to have a release unless the contract says it's some type of confidentiality. Contracts are not confidential. They're not secrets. They just can't be recorded in the public record. So I would say unless there's a confidentiality provision in that Michigan contract, then your seller who's buying in Tampa could easily turn that over to their seller in Tampa, and it wouldn't be an issue. But just double check with your Michigan attorney about confidentiality rules and make sure that you don't want to follow any Michigan laws.
Okay, thank you.
Yep. Okay. Next up, new rider DD seasonal rentals allows or prevents the seller from entering into additional leases, and it subjects the buyer to the seller's property management agreement after the buyer has had an opportunity to review it. So the seller may or may not enter into additional leases, and they may with prior approval or without prior approval, depending on what the buyer wants. And if there's a property management agreement in place, the buyer has 5 days to after receipt of the agreement to terminate the contract if they don't like it. Okay, PACE loans. So property assessed clean energy loans, PACE loans, are liens against the property. They're super liens. They supersede the mortgage. They're on the tax bill. They're paid as part of the tax bill. And this disclosure is required. So what you need to do, and you should have been doing this before, if you have a PACE loan on the property, you need to make this disclosure under Rider EE. And the way you find out if there's a PACE loan on the property, you go to the tax bill, and I should have pulled an example so everyone could see it. But you go to the tax bill and you look under non-ad valorem assessments and you look for the PACE loan. It's going to be to YGREEN, YGRENE, or some other PACE loan provider. And it's going to be paid. And again, it's on the non-ad valorem assessment section of the tax bill. It's the bottom of the tax bill. Okay. That in a nutshell is all of the major changes, not all of the major, all of the changes to the FAR forms and contracts. The as is and the regular contract, except for the inspection provision, all have the same changes. So the finance contingency changes all are in both contracts. Emily is asking, can we get a copy of the form with your markings for us to use as a sample? All right, I'm gonna do it again. Emily, I posted it to the chat, but I'm gonna do it again right now. Hold, please. So hopefully everybody can see that. That is a PDF, 2.73 megabyte PDF. That's all the changes in the red line that I just went over. And with that, what we're gonna do is, Yasmina says, do we have any PACE loans here? I'm familiar with them, but have not come across one. There are a lot of PACE loans in Collier County. There are PACE loans in the city of Naples, mostly in the River Park area. And with that, We'll take questions. Feel free to unmute yourself and ask questions, but let's be respectful. We got a lot of people on this call, so if somebody mutes themselves, wait your turn. Go ahead. Any questions?
Sam, I have a question. Representing the buyer, they were doing a conventional loan. They switched halfway to FHA because they were getting a better rate from the mortgage person. We did an addendum changing that from conventional to FHA. Now, government is holding up for one other question on the HUD. So my mortgager cannot order the appraisal. And we are about a week away from closing. Now, I did ask for an extension. Is there something in the contract that automatically gives us an extension past our original close date?
It sounds like you're still in underwriting if you're waiting on the appraisal.
No, well, that's the last thing we need is this question, according to the mortgager, to the government was waiting on one question on the HUD. That was it. And then we just can't order the appraisal until then. They won't allow us to.
So you're probably under the old contract where
Yes.
the appraisal was a second condition. So your buyer should still be protected at this point in terms of deposit.
We did send over an addendum for an extension, but did we even have to do that, or would have been there just an automatic?
No, it sounds like you're not clear to close. So yes, you need an extension. Sorry.
Okay, all right. Thank you.
Next. Other questions? Come on, you guys must have questions.
So Sam, not so much a question, but a statement. Because I work in two different markets, I come down from Chicago, have been for 16 years now. I never engage with a client unless, and I always work as in client capacity, unless they are going to be engaging an attorney. I mean, are you still seeing, is this still a norm for agents, brokers, just to go to the title company for all of this? Or are you seeing the shift where more people are going to attorneys now?
You know, that's a great question. The title company, and I own a title company. I put my closings through the title company, and of course, I'm an attorney standing here ready to help if there's ever a problem. But the difference between an attorney and a title company in Florida is very different than Chicago or any other state, because like for example, in my office, I charge the same fee. I do the same work, whether it's me, Sam Saad, the attorney, or Paradise Coast Title and Escrow doing the closing. You get the same service. So I don't really spend a lot of time worrying about, oh, it's a title company or an attorney. We just get them closed and we help everybody get it done. But I understand where, you know, some people, especially from Chicago or from New York or Connecticut or New Jersey, they want an attorney because they expect a fight. And we just don't have fights like that down here. I mean, we don't do in-person closings anymore in Florida. You're not going to sit down at the table and fight over the closing statement with the other side anymore. It's all negotiated by the realtors and the parties before closing. So I wouldn't get hung up, Marcia, on the attorney versus title company thing too much.
Well, the only thing that
your customer's comfortable with.
Yeah, exactly. I agree with you there. And the only thing that I would interject here is that I have seen on other chat rooms where people have said, oh my gosh, you know, the title company is telling us that this problem exists. Who's going to fix this? And they come to find that there is no attorney attached to that title company. And now, especially when they're people
You have
that are
that
buying.
outside counsel. Right?
Exactly. So I'm thinking, why not just address it from the start? Not that we're looking for to create an adversarial atmosphere, more about making sure that it closes, a seamless closing. So thanks for taking that question and giving me your opinion on that. But I'll always use an attorney, and I'm happy to meet with you, Sam.
Thank you.
Thank
I have
you.
some questions in the chat. If both parties agree an addendum to record the contract, can it be? Yes, you can always agree and record it. I just posted the PDF again. And don't forget, everybody, I'm going to be posting this to my YouTube channel so you can watch it again in a couple hours. I'm sure you all will want to tune in again. Let's see, make sure I got everybody's questions.
Sam, I have a question.
Yes, Eileen.
Yeah, in my situation, obviously the seller does not have a clear title. How do I determine the closing date since I have no idea how long it's going to take to clear the title?
So the closing is determined by the contract, Eileen. And if the seller cannot clear title within the clearance period in the contract, then the buyer gains the right to terminate, or they take title as is. So just look
So how
look
do I
at the timelines in the contract.
Because I wanted to see if I can put additional terms in the contract so the buyer doesn't have the opportunity to walk, so they will have to wait for the seller to clear the title. Is that possible?
That's absolutely possible. I would not recommend that if I had the buyer, but if the seller knows they've got a title issue and it's going to take some time to clear it up, I would put a date certain in there. But yes.
Okay, thank you.
All righty. Andy, you have a question in the chat.
I have a question.
One second, I got another chat question.
Oh, sorry.
It's okay, Karen. Regarding appraisals, per the new contract, am I correct to understand that unless there is an appraisal contingency, the buyer cannot terminate the contract if the appraisal comes in under? No, Andy, the appraisal has to come in during the loan approval period now. So if the appraisal comes in low, or if otherwise the buyer doesn't get the loan within the loan approval period, the buyer can terminate. So that makes it easier now. Crystal is asking, what is the name of the court case? It's Lafont, L-A-F-O-N-T, Lafont. If you Google Lafont deposit case, you'll find it. What is the name of your YouTube channel, Sonny? I don't know the name of my YouTube channel. I'm not quite there yet. I'm learning how to use it. Pearl is asking, is it unethical or prohibited for seller's agent to contact the appraiser directly? No, it's not. In my understanding, the appraiser probably wants the listing and MLS access and all that stuff, so they may contact you. That's been my experience.
I have a question.
Yes, go ahead, Karen.
Did I hear you earlier say that a cash buyer has a right to get an appraisal, and if the appraisal doesn't come in high enough, they have a right to rescind the contract?
Oh, no. The opposite of that. Let me go back to that slide and show you that.
Okay.
Under the new regime, if you do a cash contract, this is all you get.
Okay.
Finance, no contingency, no option to terminate, no appraisal, no CFPB 7 days. It's a cash deal. You close on the closing date or you lose your deposit.
That's what I thought. I just didn't hear you properly.
No problem. Thank you, Karen. Okay. Leah, I posted the red line a couple of times to the chat. Some people might not be getting it. So what I'm going to do is I'm going to email it out to everybody. So if you got an email invite to this, you'll get an email with a copy of the red line and a kind of link to the YouTube channel. Okay, we are over an hour. Do we have any other questions?
I have one clarification, please.
Sure, Yvette.
If the finance contingency is not waived within those, and then the seller has the 3 days, if the seller terminates, is the deposit returned to the buyer in that case?
Yes, it clearly states in the contract. I'll show you where that is right here. So I got it up.
Thank you. And yeah, and I'm one of the people who I keep looking in the PDF and I mean in the chat, and I can't see any.
I'm not sure quite how the PDF thing works in the chat. I'm technologically proficient. I'm just not that technologically proficient. Oh,
It did work. It did work. I downloaded it to my documents in the beginning of the
good.
class.
Good. And somebody just posted the YouTube channel. It looks like it's Sam Saad III. So that'll be up there in a little while. Yeah, Patricia, give me a call in about 10 minutes.
You absolutely need to download your PDF from chat. So it's a little confusing.
It does.
Yeah, so you must, once you open it, you have to, it won't open, you have to download it to some place on your PC or your phone.
Okay.
Mhm.
Hope that helps.
All right, everybody. Thank you very much for your time. Let me post my phone number and my email address. If you have any questions anytime, this is my cell phone.
Thank you very much. Very informative.
Thank you, thank you.
Thank you.
Very, very helpful.
Thank you. Awesome job
I
as always.
appreciate all of you
Thank
and
you.
I love your business. And if I can help you in any way,
Thank you.
call me anytime.
Thank you
Thank
so
you.
much.
Thank you
Great
all.
program.
Thanks.